Hi, my name is Goldman. I'm an attorney with Goldman and Associates. And today I'd like to talk a little bit about same-sex marriages as it relates to the division of assets. You know, in the last few years, we've had a lot of changes in the Michigan law regarding marriage, and key amongst those was Michigan's allowance of same-sex marriages. Naturally, when we allow a broader base to get married, we're going to have a broader base of people getting divorced. It's just a natural order of things. The question then becomes, how do we handle the division of assets with respect to same-sex marriages? Is it handled any differently than it always was? And to be frank, really those rules relating to the division of assets are pretty much the same, whether it's a marriage of standard format or whether it's a same-sex marriage. The court is still going to use its equitable powers to determine what would be an appropriate resolution of property issues and debt issues for that matter. The court may determine that a 50-50 division is appropriate, but the court may look at other factors too. The court may look at other things like fault factors and other things that it might use to determine the property division even in a same-sex divorce. Generally speaking, like I said, the court is very much in favor of an equitable distribution, and the court will permit the attorneys and the parties to work together toward that division of property. Unlike custody issues and parenting time issues, where the court takes a more active role in making those determinations, when it comes to property and debt resolution, if you guys come up with a solution, a resolution of your case, a division of assets or liabilities that divides it one way or another, the court will generally not interfere with that process. The court generally takes the opinion that the parties to the marriage are in better position to decide what's fair and what's not in terms of dividing who gets this or who gets that. You know, one person gets, this picture, the other one gets the next two, whatever. The court is not likely to go through all that and determine to that level of legal micromanagement. The court simply won't go there. Generally speaking, therefore, the parties will proceed under the notion that we're going to try to be as equal and as equitable as possible in the division of assets, whether or not it's a same-sex marriage. Therefore, like any other marriage, like any other divorce, the lawyers are instrumental in determining, with the assistance of the parties, what the values are and what the fair distribution should be. If you are in that situation or you have any questions about that, of course, reach out and we'll be glad to help you out.